Independent schools and special educational needs and disability law. What parents, carers and young people need to know. Bexley IAS are an independent service providing impartial and confidential information, advice and support to parents and carers of children with special educational needs and/or disabilities, and young people and children with SEND aged up to 25 years. Today's session includes some useful definitions, an explanation of different types of schools, the legal framework around independent schools, considering the voice of the child or young person, case studies, comparing a child's journey, frequently asked questions, and contact details for the Bexley Information, Advice and Support Service. Some useful definitions. SEND, special educational needs and/or a disability. A child or young person has SEN if they have a special need or a disability, which means that they require special educational provision. SEND support is the process of supporting a child with special educational needs in school. Special educational provision is when a child or young person needs additional or different support to that which is given to pupils of the same age. APDR, assess, plan, do, review. SEND support should take the form of this 4-part cycle involving the parents and carers and the child or young person. Graduated response, where the SEND support actions are revisited, refined and revised with a growing understanding of the child or young person's needs to secure good outcomes for them. Differentiated curriculum, learning that is matched to the needs of the student. Some more useful definitions. EHCNA, an Education, Health and Care Needs Assessment. EHCP, an Education, Health and Care Plan. CAMS, the Child and Adolescent Mental Health Services. SALT, Speech and Language Therapy. EP, Educational Psychology. OT, Occupational Therapy. SENCO, Special Educational Needs Coordinator. CCG, the NHS Clinical Commissioning Group. EYFS, Early Years Foundation Stage Education, the standards that school and childcare providers must meet for the learning, development and care of children from birth to 5 years old. PFA, Preparing for Adulthood. Right of appeal. This is the right to consider mediation and to appeal to the SENDIS Tribunal for changes to be made to the EHC plan, including placement. SENDIS Tribunal, the Special Educational Needs and Disability Tribunal. What is the definition of disability? A physical or mental impairment which has a substantial and long-term adverse effect on your ability to carry out normal day-to-day activities. Substantial means considerable or real and tangible. Long-term means that it's lasted or likely to last for at least 12 months. Independent schools and special educational needs or disability law. What parents, carers and young people need to know. Types of schools. The school's website or Ofsted report will give further information on the type of school that it is. The Bexley Local Offer website has more information on types of schools and local schools. You can click on the link on the presentation, or the website address is www.bexleylocaloffer.org.uk. Maintained schools are funded by the government or the Education Skills Funding Agency. Parents or carers do not have to pay fees for the child or young person to attend there. Mainstream schools. Maintained mainstream schools follow the Children and Families Act 2014 and the Special Educational Needs and/or Disabilities Code of Practice. Maintained mainstream schools may provide special educational needs support as part of the assess, plan, do, review cycle. The Children and Families Act requires mainstream schools to provide special educational needs support to children and young people who may have special educational needs. A medical diagnosis is not required to access support. There is a fundamental right to mainstream education. The fundamental principle underpinning the law is that where a parent of a child with special educational needs or a young person with SEND wants a place in a mainstream setting, it must never be denied on the basis that mainstream is unsuitable or that their needs or disabilities are too great or complex. Mainstream schools must be inclusive. Resource provisions. Resource provisions vary from setting to setting. A resource provision often consists of a small class within a mainstream school. Children will generally access the mainstream curriculum with differentiated teaching and support. Children attending a maintained resource provision will often have an education, health and care plan. Maintained resource provisions follow the Children and Families Act 2014 and the SEND Code of Practice. Special schools. Special schools offer small class sizes, a highly differentiated curriculum and specialist resources. All pupils attending a special school will have been identified as having a high level of special educational need. Children and young people attending a maintained special school will have been referred by the local authority, and the majority often will have an education, health and care plan. Maintained special schools follow the Children and Families Act and the SEND Code of Practice. Alternative provisions. Education arranged by local authorities for pupils who, because of exclusion, illness, or other reasons, would not otherwise receive suitable education. Education arranged by schools for pupils on a fixed period exclusion, and pupils being directed by schools to off-site provision to improve their behaviour. Maintained alternative provisions follow the Children and Families Act and the SEND Code of Practice. What are independent schools? Sometimes called private schools, independent schools are schools where the parent or carer may pay the school fees for their child to attend that school. These schools are often not funded by the government. This is different from mainstream schools, resource provisions, special schools, or alternative provisions which are maintained, which means that the parent or carer does not have to pay school fees. These schools are funded by the government or the Education Skills Funding Agency. Did you know the Children and Families Act 2014 and the SEND Code of Practice do not apply to wholly independent schools, and so these duties do not apply to them? Click here for more information on the Special Educational Needs and Disability Code of Practice. The Children and Families Act 2014 and the SEND Code of Practice require schools to identify children who may have special educational needs, provide special educational needs support in the process of assess, plan, do, and review. A medical diagnosis is not needed to access this support. If support is not ensuring progress, the school should contact specialists for advice. If support is still not ensuring progress, the school should make an application for an Education, Health and Care Needs Assessment from the local authority. Employ a Special Educational Needs Coordinator, a SENCO, in all maintained mainstream schools. Have a Special Educational Needs Policy and publish a SEND information report. Independent schools may not be required to follow the Children and Families Act and the SEND Code of Practice. Some independent schools are not legally required to identify children who may have special educational needs or provide the SEND support outlined in the SEND Code of Practice. Some independent schools are under no obligation to contact specialists for advice on a child's needs. Some independent schools are not required to make an application for an Education, Health and Care Needs Assessment. Some independent schools are not required to employ a SENCO, have a Special Educational Needs Policy, or publish a SEND information report. A policy are written guidelines that staff should follow. The Independent Schools Standards is guidance for independent schools to follow. There should be a written policy on the curriculum. Proper consideration should be given to ensuring that the written policy, plans and schemes of work meet the needs of all individual pupils in terms of their ages, needs and aptitudes, including those with special educational needs, that all children will have the opportunity to learn and make progress. Click on the link for more information. The Equality Act is law that applies to all schools and education settings. Independent schools must not discriminate against disabled pupils and must make reasonable adjustments where necessary to avoid disability discrimination. A reasonable adjustment is a change or set of steps taken by a school for the benefit of a pupil who is at a substantial disadvantage. For example, a reasonable adjustment may be that a child with a visual impairment sits closer to the board so that the board is easier to read. In order to show that the student has a substantial disadvantage, a medical or professional report, professional evidence, or medical diagnosis may be required. Different types of independent schools. Section 41 schools. Some independent schools are Section 41 schools, which means that they have chosen to follow the Children and Families Act 2014 and the SEND Code of Practice. Bexley, Greenwich and Lewisham boroughs do not currently have any Section 41 schools. Bromley Borough has Baston House, the Tutorial Foundation and Nash College. Non-maintained special schools. These schools are required to have regard to the SEND Code of Practice. Bexley, Greenwich, Lewisham and Bromley boroughs currently do not have any non-maintained special schools. There is Meadows School and the Caldecott Foundation School in Kent. Independent special schools. This means they may have a SEND focus. For example, an independent school which specialises in supporting children or young people with learning difficulties. These schools are not legally required to follow the Children and Families Act 2014 and the SEND Code of Practice. Bexley has Parkview Academy. Wholly independent schools. These schools do not have a SEND specialism and do not have a legal duty to follow the Children and Families Act 2014 and the SEND Code of Practice. Bexley has West Lodge School and Merton Court Prep. For more information on types of schools, the Bexley Local Offer website has more information about the type of schools, and the current list of Section 41 schools can be found on the Bexley Local Offer website. Click on the link for more information. The government website has more information on types of schools, and you can click on the link for more information. When considering schools, it is important to consider the voice of the child or young person. The most important person in this process is the child. What support do they need or want? How are you capturing their voice? For more information on one-page profiles, click on the link which goes to the Bexley IAS website. Case studies. Some case study examples and possible solutions. Case Study 1. My child attends a wholly independent private school, and I, as a parent, pay the school fees. My child does not have a diagnosis, but I know that my child has special educational needs. He does not seem to have made progress since he started there in reception. I have offered to pay for an educational psychologist report and any support that my child needs, but the school has refused to do this. The school has also refused to apply for an education, health and care plan for my child. The school have complained about my son's behaviour and told me that he could be permanently excluded from the school. What could this parent or carer do next? Case Study 1. Possible solutions. Independent schools may have a special educational needs and disability or SEND policy. This is often found on the school website. Policies are written guidelines that staff should follow. The SEND policy should tell you how the school supports children or young people with SEND. Other policies on the school's website, such as the behaviour policy, will tell you about the school's expectations of behaviour and the school approach to discipline. The school should follow the independent school standards. If the school is not following its own policies or the independent school standards, you may wish to follow this as a concern or a complaint. The parent may consider raising a claim of disability discrimination against the school. The parent may consider doing a parental request for an EHC needs assessment. Case Study 1. Possible solutions. Making a complaint. The parent may wish to explore requesting the child's educational record so that you see the evidence of the child's progress and any support they may have been given. Doing a subject access request so that you have a copy of all documents which have the child's name on them. In order to make a school complaint, follow the school's complaint procedure, which should be on the school website. Case Study 1. Possible solutions. A disability discrimination claim. In order to make a successful disability discrimination claim, the parent may need to establish that the child has a substantial disadvantage. A diagnosis of special educational need or disability qualifies as evidence that the child has a substantial disadvantage. Without a diagnosis, the parent may need to seek medical evidence from professionals to establish that the child has a substantial disadvantage. Once a substantial disadvantage is established, the parent may need to demonstrate how the child has been treated differently from their peers as a result of their disability. The parent may need to seek legal advice, possibly from a solicitor. Case Study 1. Possible solutions. Completing a parental EHC needs assessment request. Once the parent has submitted an EHC needs assessment request, the local authority will respond within 6 weeks to confirm if they will grant an EHC needs assessment or refuse an EHC needs assessment. If an EHC needs assessment is granted, assessments will take place to find out more about the child's needs and any support that they may need. As part of the EHC needs assessment process, the parent will need to let the local authority know their parental preference for their child's school placement. If an EHC needs assessment is rejected, the parent has a right to mediation or appeal. Case Study 1. Possible solutions. Do not deregister your child from the school without securing another school placement first. Do not feel under pressure to home educate your child. Elective home education is a big step where the parent assumes full responsibility for their child's education, including any costs. If you decide to withdraw the child from a private school and you as a parent are paying the fees, you may still be liable to pay school fees. You may need to give at least 1 term's notice when you want to withdraw your place. If your child is of compulsory school age, your child has a right to full-time education in a maintained mainstream school by law. For more information on your child's rights and the Education, Health and Care Needs Assessment application process, visit the Bexley IAS website. Click on the link for more information. Case Study 2. My child is currently at a maintained mainstream school. They have an education, health and care plan. However, the school are beginning to say that they can no longer meet my child's needs. I have seen an independent school which looks like it would really suit my child and benefit them. What could this parent or carer do next? Case study 2, possible solutions. The parent could speak to their child's EHC plan case officer to request a review of the EHC plan. A review is an opportunity to talk about what is going well and what is not going well at the current placement. It may be through discussion of the needs of the child or young person and the support they are receiving that a solution can be found in their current placement. As part of the review process, the parent has a right to request a change of placement. Case study 2, possible solutions. Change of placement is normally requested during a process of review. The parent or young person has a right to request any of the following types of school or college: a maintained school or nursery, mainstream or special, an academy, mainstream or special, an institution in the further education sector, a non-maintained special school, a Section 41 school, which is an independent school that has chosen to follow the SEND Code of Practice and the Children and Families Act. Case study 2, possible solutions. Why does the parent or young person not have the right to request a wholly independent school? Unlike maintained schools, such as mainstream schools or special schools, the local authority cannot direct independent schools to admit a child or young person. This does not mean that you cannot ask and argue for a place at an independent school. Where a parent or young person is requesting an independent setting, they will generally need evidence from a professional as to why the independent setting is the only school or college which can meet the child or young person's needs. Additionally, an offer of a place from the independent setting is required. Case study 2, possible solutions. Why may a school placement request be refused by the local authority? The only reason the local authority can refuse the request is if the setting is unsuitable for the age, ability, aptitude, or special educational needs, SEN, of the child or young person, or the attendance of the child or young person would be incompatible with the provision of efficient education for others, or the attendance of the child or young person would be incompatible with the efficient use of resources. For more information on EHC plan reviews, visit the Bexley IAS website. Click on the link for more information. Case study 3. My child attends a private school or independent school and I pay the school fees. They have recently been diagnosed with a special educational need and/or disability. I'm unsure about what reasonable adjustments should be put in place. What could this parent or carer do next? Case study 3, possible solutions. The Equality Act 2010 requires schools to make reasonable adjustments for children or young people who are at a substantial disadvantage. Information on reasonable adjustments can be found on the Bexley IAS website. Click on the link for more information. When a child or young person receives a diagnosis or a medical or professional report, there may be professional recommendations. This is advice from a specialist. These recommendations are examples of support or reasonable adjustments that could be put in place by the school. Case Study 3, Possible Solutions. As a parent, carer or young person, you can request reasonable adjustments. The term reasonable is not explicitly defined in the Equality Act, which leaves it up to the discretion of the school to determine this. Some, but not all, of the factors that may influence a decision are financial resources of the school, cost of the aid or service, effectiveness of the aid, effect on other pupils, health and safety requirements. What is deemed to be a reasonable adjustment may also shift depending on the circumstances of the case. In fact, despite the fact that the legal duty applies to all schools, regardless of whether they are publicly or privately funded, there can still be discrepancies in what is actually provided. It may be dependent on school resources. Case Study 4. My child has an EHC plan. At annual review, we requested a change of placement. A professional report recommended that my child have specialist provision which matches the description of an independent school. We have requested that my child attend that independent setting. However, the local authority has asked the independent school if they agree to a placement, and the independent school are refusing to offer my child a place. What could the parent or carer do next? Case Study 4, Possible Solutions. The local authority cannot direct a wholly independent school to admit a child, even if the child has an EHC plan. The independent school needs to agree to a placement and offer a placement. Independent schools, which are not Section 41 schools, do not need to abide by the Children and Families Act 2014, the legal framework for EHC plans, and the SEND Code of Practice. The parent or carer could ask for the EHC plan to be amended or changed during the process of annual review to include the recommendations from the recent professional report. When the EHC plan is finalised, the parent or carer will be notified of their right of appeal. The parent could explore other placement options as described on the Bexley Local Offer website. Whatever is written in the plan is what should be delivered by the current setting. There is a duty to secure the provision in the EHC plan. The parent has a right to make a formal complaint against the school and the local authority if the provision specified in the EHC plan is not being delivered. Final thoughts. Maintained mainstream schools where parents are not charged school fees must comply with the Children and Families Act 2014 and the SEND Code of Practice. There is a legal duty to identify children who may have special educational needs. There is a SEND support cycle of assess, plan, do, review. This support is available to children or young people who may have special educational needs. A diagnosis is not required to access support. There is a fundamental right to mainstream education. If a child or young person has an EHC plan, the local authority may direct a maintained mainstream school to admit a child or young person if it considers it to be appropriate. Maintained mainstream schools must ensure that their policies, such as behaviour and exclusion policies, are legally compliant. There are policies and procedures that must be followed, and there is a duty to consider the child or young person's special educational needs. Final thoughts. Private or independent schools where parents may be charged school fees. Only if the school is a Section 41 school does it have a legal duty to comply with the Children and Families Act 2014 and the SEND Code of Practice. Wholly independent schools are not legally required to identify SEND or provide support outlined in the SEND Code of Practice. However, all schools must comply with the Equality Act 2010 and make reasonable adjustments for a student with a substantial disadvantage. The local authority cannot direct a wholly independent school to admit a child or young person. If a child or young person has an EHC plan and the family considers a wholly independent school to be the right placement for their child, the onus is on the parent to prove that the place is suitable. The parent may need to have an offer of a place from the school and evidence from a professional. The local authority must agree to the placement. The statutory school exclusion guidance published by the Department for Education does not apply to independent schools. Exclusion from an independent school is dictated entirely by the contract between the school and parent. The contract would need to be consulted in conjunction with the school's policies in order to determine the legal position. Comparing a child's journey. Child X's journey. Child X is 6 years old. The parent has noticed that the child seems to be behind in their learning and struggling at school. The parent has noticed that the child may have special educational needs. Let us compare Child X's journey. At a maintained mainstream school, the SEND Code of Practice states, parents know their children best, and it is important that all professionals listen and understand when parents express concerns about their child's development. They should also listen to and address any concerns raised by children and young people themselves. The parent speaks to the school to raise their concerns. The school is required to have a special educational needs coordinator, a SENCO, whose responsibility it is to coordinate the support of its students who may have special educational needs. The school must follow the SEND Code of Practice, which has a duty to identify children who may have special educational needs. The school may follow the assess, plan, do, review cycle to put a plan of support in place for the child. A diagnosis is not needed to access this support. At a wholly independent school, the parent can raise concerns with the school. The school do not have a legal duty to identify and support the child in the same way as the SEND Code of Practice. The school may reassure the parent that they will comply with the Equality Act and put in any reasonable adjustments needed for the child. The parent may be unsure about what reasonable adjustments to request, and the school are not legally required to have a special educational needs coordinator, a SENCO. At this point, the parent could seek independent advice. At a maintained mainstream school, Child X is receiving SEN support. However, progress has not been made. The SEN Code of Practice states, where a pupil is receiving SEN support, schools should talk to parents regularly to set clear outcomes and review progress towards them, discuss the activities and support that will help achieve them, and identify the responsibilities of the pupil, the parent, and the school. Schools should meet parents at least 3 times each year. As part of the SEN support cycle outlined in the SEN Code of Practice, the school may seek advice from specialists to understand more about Child X's needs and provision. Provision is what is done to meet the child's needs. The specialists may give professional recommendations which must be put into place by the school. The school are obliged to consider that if this support does not ensure progress, they may need to plan further or request an EHC needs assessment from the local authority. At a wholly independent school, Child X has not made progress. The parent may have now raised concerns a few times with the school. The school are under no obligation to provide special educational needs support or seek advice from specialists to understand the child's needs further. The school are under no obligation to support an EHC needs assessment request or do an EHC needs assessment request. The parent now feels that getting a diagnosis for the child may be a way of accessing more support. The parent feels that a diagnosis may give a greater understanding of the child's needs. Also, if the child has a diagnosis, they may be protected legally under the Equality Act 2010. Doctors may inform the parent that the waiting list for an assessment is long. Frequently asked questions. My child has SEND. Can an independent school refuse to give them a school place? Independent schools can exercise greater discretion with respect to formulating their admission arrangements compared to maintained schools and academies. Independent schools set their own admissions criteria. Independent schools, for example, can refuse to offer a place based on academic ability. It is important to note, however, that the Equality Act 2010 prohibits discrimination by schools against pupils or potential pupils in relation to admissions on the basis of protected characteristics, and this applies to all schools, including independent schools. The local authority cannot direct an independent school to admit a child or young person. My child attends a wholly independent school. They do not have an EHC plan. Are they entitled to support? The school is not required to identify what special educational needs your child may have. This is a legal duty in maintained mainstream schools. The school must put in place reasonable adjustments for any child with a disability as required by the Equality Act 2010. The school can ask for evidence of a disability that your child is at a substantial disadvantage, for example, a professional or medical report, in order to put in place appropriate reasonable adjustments. My child has an EHC plan. Can the local authority refuse a placement in an independent school? The local authority is not under the conditional duty to name the provider, but must have regard to the general principle in Section 9 of the Education Act 1996, that children should be educated in accordance with their parents' wishes, so long as this is compatible with the provision of efficient instruction and training and does not mean unreasonable public expenditure. You can ask and argue for an independent school. Evidence from a professional that the independent setting meets your child's needs may be required, and there must be an offer of a place from the independent setting. However, the local authority can refuse a placement in an independent school. When the EHC plan is finalised, you will be notified of your right of appeal. My child has an independent school named in Section I on their EHC plan. Does the school have to carry out the provision on the EHC plan? If an independent school is named in Section I of an EHC plan, they have agreed to carry out the provision specified on the EHC plan. If the school is not carrying out the provision specified in the EHC plan, you can contact your child's EHC plan case officer at the local authority. It is the local authority responsibility to secure the provision in the plan, and it is the school who carry it out. You can contact the Bexley Information Advice and Support Service for impartial and confidential information and advice. The telephone number is 0203 045 5976. The email is bexleyIAS@bexley.gov.uk. The website is www.bexleyIAS.co.uk. Bexley IAS endeavours to respond to all inquiries within 3 working days. Thank you for listening to this presentation.